Number 79, People v. Rakeem Douglas.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Rakeem Douglas. I'd like to reserve 3 minutes for rebuttal, if possible.
You have 3 minutes, Mr. Strother.
This court should reverse Mr. Douglas's conviction because the inventory search in this case was carried out pursuant to a facially unconstitutional inventory search procedure.
And that, I just want to be clear, that is your claim. It's a facial claim, facial unconstitutionality of the police guidelines.
Yes, we're arguing that section 218-13 does not satisfy constitutional.
And I'm sorry, just to take a line from your reply brief, you said your core claim is that constitutionally sufficient inventory search protocol must create a procedure for securing property during any delays in the inventory process. Is that your core claim?
Our core claim, yes, but a quick explanation. In People v. Gallick, this court held that an inventory search procedure has to serve the purposes of inventory search and limit discretion. Those purposes are to secure property and prevent against claims of loss or theft. So if the procedure, as this one does, undermines one of those purposes, it's not serving it, and therefore it can't justify a search. And
the deficiency, facial deficiency in this procedure is it doesn't provide for securing the property during delays in the inventory process.
That, and also, I think it's also important to point out that it provides officers with unfettered discretion to do whatever they want with the property between the time they seize it and when they make the voucher.
There's a variation on that.
Yes, and of course that time limit is unlimited. It could be...
So what is the minimum that you could add to make this procedure valid?
I believe the NYPD, because it's clear they know how to secure property, right? They have other provisions that require at different points in time. I think this court would have to hold that an inventory search procedure must make some provision.
No, I'm asking you something different. You get to take the pen to their policy. What's the minimum you could add for us to be able to say this is okay?
I believe it would have to tell officers to either make a contemporaneous list of the property as they seize it, which is pretty standard in some other jurisdictions, or tell them to put the property in a secure location and probably define what that is, while there's going to be a wait before the voucher. This isn't an onerous thing on the police department. It's very common for them to do stuff like this in other circumstances.
So under what this suggestion that you've just, or your response to Judge Wilson, if they had put everything in the bag, not made a list at that time, perhaps not even other than the gun, really focused specifically on what's there, and then brought that bag into the precinct, did they immediately need to do something, or could they have, let's just say, put it in a secure location and come to it for the moment, we'll just say an hour later. Let's make it easy. Would that have been okay?
If the protocol says put it in a secure location and say provide some examples of what those are, and it goes there, and that is a place where the property is safe, that's fine. That's
how long can it be in that secure location before they actually, under the hypothetical I gave, before they actually make a list, voucher, whatever they're going to do to now go through what they took out of that car and have some kind of inventory of it?
As long as the property is secure, in a secure, like nothing's going to happen to it. I mean, they could take the time they need to take. And I wouldn't want to.
Is your complaint here that it's the combination of a lack of securing and the unlimited time together?
Yeah, because in those circumstances, this gets at what the Supreme Court was trying to get at in Illinois Lafayette, is that in the absence of that time, when that big long time period is there and there's no provision for doing anything with the property, that's how property gets lost, stolen, or contaminated.
Let's say there's a list, and it says, I have this shirt, and it's striped, I have this pair of pants, the khakis, the label, its size, and I have this, pair of shoes, size 9, the type, and I have a gun. And that's my list, but I don't well, I probably would secure the gun, but let's say I have this list and I don't secure it, but I have this list and here's the property, why isn't that an inventory
Do you
search?
mean, do you have that list at the time you seize it? You make it at
Well,
that
I
time?
make it within as I'm doing it, a couple hours go by, but I make this list up, and it's, here are the 4 things I took out of the car, and they're listed on here, and I give 3 of them back, and I keep 1. And
So-
I have a record, I gave you 3 back, and I kept 1. Why isn't that an inventory search?
The reason why because if a procedure doesn't tell you to do anything with the property during that time that you're waiting, this is where things can happen to property. The whole point of it provides the officers with the discretion to sort of do what they want, right? They could, as in this case, throw it in a garbage can. They could toss it under their desk. They could leave it in a corner. If it's in a garbage bag, a janitor could think it's trash and throw it away. Someone could plant evidence inside of it. Someone could steal something from it. And if there's no list in front of them that they made when they did the search, they're not going to know that the property changed during that time.
What our test seems to be from Gallic is the procedure so unrelated to the underlying justification for an inventory search, right? Those are the factors we were looking at: time, what they were doing with it. But is the procedure as written here, because it's a facial challenge, is the procedure as written here so unrelated to the underlying purpose of an inventory search as to render any inventory search done under that procedure invalid?
I believe so, yes, because inventory searches are not investigative searches. The entire purpose of them is to make sure property is secured. If there's no time limit on when they have to actually make a voucher, and there's completely unfettered discretion, which of course is the thing they're supposed to prevent to officers, to just do what they want with the property in the interim, what that looks like then is find the incriminating evidence, do something with that, but the rest of it can just sit there and whatever happens to it, and I'll get around to the list at some point. At that point, it doesn't really look like they're actually trying to secure property. It looks like...
Okay, so when you responded earlier that as long as it's secure, they can take as long as they need to, what would be the outer limits of that?
I mean, I have to be honest.
I mean, there'll always be competing demands on an officer's time. We understand that.
So I don't think I could give an exact number, right? And I don't think this court actually has to either. I think, I will say the 11 hours in this case is very long, right? And that's much longer than this court authorized in Gallic. And I've actually not found a case where 11 hours is justified solely based on ordinary arrest stuff that this officer's doing.
I thought it's supposed to be a reasonable time.
What's that?
I thought it's supposed to be a reasonable time.
It's supposed to be a reasonable time under the Supreme Court's case law. They say within a reasonable amount of time.
Would saying as soon as practicable, if they can then explain at a hearing what they were doing during that time, satisfy it?
It could if, I want to say though, I'm not 100% comfortable with practicable including this situation because every single arresting officer has to do the stuff that Officer Burgos had to do in this case. Fill out paperwork, complaint reports, make phone calls. If that's the justification, there will always be a reason to have a long delay.
But this officer had to call in a special unit to inspect the gun, didn't he?
Yes, but he didn't finish the inventory until 7 hours after that was done either.
Well, suppose it's a small department, and then there's a shooting, and 5 cars go out, but you only have 5 cars in the department, and they don't get to it until 10 hours
I
later.
think legally that's a separate scenario. There's an emergency situation where courts have looked at this differently. If there's an emergency, of course, officers can respond to the emergency first. We're talking about delay as a result of ordinary police work, which is what...
But then aren't we delving into the micromanagement that we said we don't want to do?
I don't think so. I mean, courts have numerous cases where the police are allowed to do certain things because of emergencies that they're not in other circumstances. The distinction between emergencies and ordinary police work is pretty easily understandable. One is a shooting. The other one is, I got to fill out a complaint report for an arrest I just made. That's not an emergency. That's just ordinary arrest work. But the point being, as soon
What if
as...
they've got to fill out paperwork for a mass shooting?
If you got to fill out the paperwork for a mass shooting and you need to...
But that's different from, not to, of course, disparage the loss of life. I'm not suggesting that in any way. But in terms of the volume of the work that an officer might have to go through and the timing, you would agree, yes? It would be different if it's a mass shooting, perhaps with many complexities attached to that. Maybe the shooter is still out there and one person dead. Perhaps you've got the shooter.
I think if this court, if you create a flexible standard that says as soon as practicable and you're allowed to take it into the circumstances, those cases can be decided. However, the property is if it's actually secured and not going to be lost, contaminated, or stolen, that serves the purpose of the inventory search. That's what's missing from the protocol.
That's how I took your earlier answer, is if we imagined, and this wouldn't happen, but if we imagined that the department had individual locked safes for each inventory search, and there was a procedure to immediately, take the property and put it there, and only one officer, or two had the ability to get that, and you had to log in and out. Imagine whatever safety procedures you want. You wouldn't care so much about the time.
No, because, I mean, you think about it like we look at Section 218.01, which the prosecution offered in this case. That has nothing to do with what happens to property before it's vouchered, which is what we're claiming. But they make a provision for after it's vouchered, right? It goes to a desk clerk. They hold it there until someone comes and picks it up. They have ways of doing this. They just don't make anyone do it.
So they
for
could put it in a
me.
locker and leave it for a week?
As long as it's locked and nobody else can get into it and
matter.
it's safe, that's fine. Because the whole point is it's not supposed to be lost, stolen.
So is it akin to like chain of custody in a drug case? You put it in, so you know it's secure because you can establish where it's been from the time it was picked up until the time it's retrieved from the secure location.
That would be a good example of it. And, the reason that you need this stuff is because if a protocol's not doing that, if it's not actually securing property for hours and hours and hours, I mean, that's the whole point of an inventory search.
But it does strike me as at odds with the Supreme Court. The Supreme Court has said it's got to be within a reasonable time. No, you can't keep that thing for 5, 6, 7, 8 days just because.
Oh, I mean, I think that there's got to be an outer limit to which it's unreasonable,
That
of
was
course.
my-
But
all right.
I just
I
don't
was
know if I
asking
could.
that.
I don't know if I could tell you when that would be. I mean, I think, you would have to go through.
Well, I think you have suggested it's a reasonable time, assuming no exigent circumstances.
Yes,
And a
and it
reasonable
had-
time, if I'm understanding you correctly, excludes time on routine administrative matters.
Yeah, I don't think you could spend, a half day or a day or 2 days saying, well, I have to do every single other thing.
See, this is the conversation I think some of the judges are concerned about, right? That this is about what the NYPD might think is within their discretion about what needs to be done in a particular priority.
And that's
if
why-
it's secured, going back to your point, then what's the harm?
And that's why I'm suggesting to the court that if a protocol makes provision for security, you don't really have to worry about the time too much beyond saying reasonable, it has to be within a reasonable time, as the Supreme Court said, and you can adjudicate that case by case as long as the property is secure, because
Thank you,
then
counsel.
nothing's going to happen.
Can I just ask one more question?
Sure.
But what about vouchering? You mentioned vouchering. Why isn't vouchering securing?
Because there can be, right now, an indefinite period of time before it's vouchered.
Okay, so what, is it the time or is it the security? I guess that's what we
It's a
keep-
combination of the two. If without security, the time becomes a problem, right? Because then the property, at that point, the police they can do whatever they want. They can leave it sitting anywhere. It could be lost. It could be stolen. If they voucher it immediately, and of course then there are other parts of the patrol guide that take over and provide for security after it's vouchered. But until it's vouchered, there's nothing in this protocol about what happens to this property. Cops can do whatever they want with it. At that point, that's when things can go wrong. That's when it could get stolen, lost. I mean, we could, a cop could plant evidence, a janitor could throw it away, someone could accidentally lose something, and we wouldn't know. There'd be no way to know that that's what happened. That's the opposite of what an inventory search procedure is supposed to make happen. It's supposed to secure the property.
Thank you.
Good afternoon, and may it please the court, Stephen Kress on behalf of the people. First thing I want to address is preservation. It's a threshold jurisdictional question. The defendant's facial challenge to the NYPD's inventory search protocol is just not preserved. He simply never made this argument below. In fact, he actually made a facial challenge, but on different grounds, and I'll direct the court to page 133 of the appendix, where he says the NYPD's inventory search protocol is facially unconstitutional because it gives police officers too much discretion in how they actually conduct the search. He just never raised this argument. And as my adversary told the court on his opening argument, the linchpin of his claim is, I think, this idea that the policy doesn't speak to securing property, which I don't necessarily agree with, but that is, that's the crux of his claim. And
But his point, if I'm understanding him, he'll correct me if I'm wrong when he gets up on rebuttal, is that if you don't give guidance or say specifically it has to be secured and then give guidance of as to how one would do that, that leaves it to the unfettered discretion of the officer. Why isn't that then preserved?
I'm sorry, what was the last part of your
Why
question?
isn't that then preserved?
I mean, because I don't think
I
it's
mean,
enough.
the point is that it's not giving guidance and cabining the discretion of the officer.
I just don't think that it's not specific enough, it's not specific enough to say, well, this policy gives police officers too much discretion. In what way does the policy give them too much discretion? He's saying it's because it allows them to do whatever they want with the property, which again, I don't agree with that. But he actually made a different argument, which was it gives them too much discretion in how they actually are physically searching the car and not what they're doing with the property after it's been recovered. So I just don't think it's been preserved. And I know on reply, defense counsel said, well, you know, I would have raised this argument, but the court cut me off. But I think the record undercuts that claim. Again, if you look at page 133 of the transcript, counsel was undeterred by the court's comment. I mean, yes, the court did say, we're not going to have a referendum on the constitutionality of the patrol guide, but counsel then raised a facial challenge to it. So I don't think it's a fair reading of the record to say that the court cut him off. And in any event, I would also cite to People v. Keshner, which is 25 New York 3rd 704. And in that case, this court applied the preservation requirement.
So let me ask you this. If the court had cut him off and counsel then didn't say anything at all, preserved?
No, Your Honor, that's Keshner. And so in that case, defense counsel had made an argument, and the court said, okay, that's fine. And then counsel said, secondly, and the court cut him off and said, I think exactly, no, we heard this argument. And defense counsel then didn't go on to say anything else about it, and this court said, no, it was unpreserved. It wasn't enough in that case because you never raised the issue. And the court expressly distinguished Rezick, which is a case that defendant cites in his brief, where, you know, the defendant had raised a claim over and over again, and eventually the court said, enough is enough, I don't want to hear this anymore. And in that case, the court said, well, it was preserved, you did raise it, and the court made a reference to, you know, you don't have to keep trying the court's patience here.
So your position is if a court cuts you off and says, as here, we're not going to have a discussion about the facial constitutionality, has removed from counsel's strategic arguments this one argument, that counsel nevertheless has to say, I'm ignoring the court's directive, I'm going to move forward. That's the only way they would preserve it. Is that your view?
Well, I think...
Assuming the court doesn't cut them off again.
Right. Or I guess the court could, it could theoretically ultimately decide the issue, which is, I know, another
Yes.
Argument
Yes.
that they raised.
Yes.
That could be a potential way.
Decide the issue without having heard the argument?
I mean, I think if it had been potentially raised, like, for example, if during cross-examination during the suppression hearing, if counsel had been teasing out facts to try to set up this argument, I think the court might have been aware of, okay, well, I think this is where he's going with that, and the court might address it. I think that's happened in other cases.
I mean, it doesn't address when it's the first opportunity to make the argument, but fair enough. I'm not going to say otherwise to you. It is a bit odd that, in part, the preservation rule exists to allow, right, the court to address the issue and perhaps to avoid an appealable issue. And if the judge themselves says, I don't want to hear it. I'm not going to allow that argument to be made, that the defendant has the door closed on them, the appellate door closed on them. It does seem a bit odd, no?
I mean, I don't know if it's odd or not. I mean, I think it's ultimately, it's the defendant or the appellant's obligation to create a record that's reviewable for appeal. And so I think whether the court is trying to cut you off, I mean, it's ultimately, I think you could say that in response and say, Judge, look, I have an obligation to make a record for review on appeal, and I'm going to do that. And I understand that could be challenging.
There is a point at page 139 of the appendix where the colloquy suggests a complaint about the timeliness, and the court responds to that and says, I don't think it's unusual for these things to take a lot of time. Does that preserve it?
I don't think it preserves his whole claim, because he's not just challenging the timing of it, as I think defense counsel was pointing out. It really has sort of three pillars to his argument. And they all turn on the security problem, because I think he's saying, well, if it's unsecured, then you either need a contemporaneous list or you need some sort of, time restriction on it.
Is he challenging the timeliness? Again, he can clarify on rebuttal, but what I understood the argument to be is that if you provided for securing of the property, that how much time it takes thereafter to create the list isn't as urgent.
Yes, I agree.
Analysis.
I agree. I think that is the claim here, that if you have the property secured, then the timing aspect becomes less important. And I think the same thing with the contemporaneous list.
So what's wrong with that argument? Secure the property in a safe location so that it's not subject to theft or accidental loss or destruction, and then you can go ahead and apply the policy as written without constitutional infirmity. What's the missing piece of that argument?
Well, I don't know if I'm not sure I understand your question, Your Honor. I mean, I think this protocol, there's nothing wrong with requiring.
The question is, why shouldn't there be a requirement that property that's not inventoried yet needs to be secured?
I see. I think that, I think there could be a requirement, and I think this policy satisfies that. I think you could say, yes, property has to be secured until it's properly inventoried, and this policy actually, the very first thing that it says, if you're looking at section 218.13, it says the purpose of this policy is to protect property. And actually, testimony of the two officers in this case, I think, makes clear they understood that to impose an obligation on them to secure the property, and that's actually what they did.
I have to say, I'm a little skeptical about that when one of the things that the policy instructs the officers to search are the air vents of a car, which people don't usually put property other than maybe contraband in the air vents of their car, do they?
I think the policy authorizes the search of anywhere where there could be valuables. I'm not, to borrow
What do you have in your air vents right now?
So I was just about to say, Your Honor, I'm not a Mona Lisa Vito here. I'm not a car expert, but I don't know. I guess maybe something could get sucked in there. Maybe something could get sucked in. A valuable could get sucked in there. I'm not sure.
Wasn't there a case involving speakers where they took the speakers out and they looked there? Or am I making that up? But
No, Your Honor. That is one of this court's cases. I believe it is Padilla. I think that's.
Does the record here clearly support that the property was secured?
I believe it does, Your Honor, yes. I believe Officer Burgos's testimony established that.
What did he say that established that? Because he's saying it's only the testimony, correct? Nothing but his testimony. That's what we're measuring this by, because he's the one who described the policy and what he did?
Well, both officers described the policy, but I think if you're talking about in terms of actually securing this property in this case, it's Burgos's testimony.
But do you think the other officer added something regarding the policy that Burgos's testimony does not already present and clarify?
Yes, I do.
Okay, all right.
So the second officer, Bash, he can't speak to the specific facts of the securing in this case, because he said I had left for the night. But he does testify about how it was his view that this inventory search protocol imposed an obligation on the officers to safeguard items recovered from the call. So I think that's where he adds something.
So then it's not Burgos's testimony?
Well, Burgos says that as well. Okay. But Burgos's testimony goes specifically to, was this property in fact secured in this case? And so...
And he said?
And so he starts off by saying, look, when we find the gun has to stay where it is. I can't pick it up. I can't bring it away. Mm-hmm. And so I think then he goes on to say that, look, one of my duties is to safeguard the evidence in the case. That would include the gun. And he can't actually start the inventory process until evidence collection comes and finishes what they're doing. And so I think the fair reading of all of that is that he's outside in the parking lot with the gun for 4 hours. And given his testimony, which is on pages 18 and 19 of the appendix, where he says, look, the reason why we're bringing this car in is to safeguard the defendant's property. That's the whole point of this. I don't think it would be a fair inference to say that while he's outside, the other property from the
But-
car,
but
which
that-
includes other arrest
But
evidence.
it's your burden, not yours, obviously, my apologies, the prosecutor's burden, right? To have established that he met the protocol and that it's a constitutional inventory search. And it's hard to conclude this officer's just standing around in the parking lot 4 hours and doing nothing else but watching the bag?
Well, he's watching the gun, Your Honor. And I, remember, this is a
Well, okay, so
loaded...
then where's the bag? Let me try it that way.
So I think the bag is also outside there with him.
Okay.
Okay. Yes, it is our burden. I think we established it here. And then after evidence collection is
So
finished...
you're saying that's the credited testimony about the securing, that he stayed with the car? Well, he did say he stayed with the car for 4 hours, did he?
He doesn't expressly say that, no. I think that's the only reasonable inference you can draw from the things that he does say, which is that the gun had to be kept outside. I have to watch it. It's my responsibility as the arresting officer.
Never had to go to the bathroom. Never went inside.
I
Never had a
don't...
call. Never had an emergency.
I-
Didn't have someone come and stand there while he goes.
There's nothing in the record that would indicate that those things happened.
Okay.
Thank you, counsel.
I'd like to address both preservation and then this last point about the record in the case. This claim is preserved. I want to make 2 points as to why. For one thing, my adversary's summary of what counsel argued is not quite correct. The first thing he does is on page 128, he cites Gallick, the case that we rely on most heavily. Then he argues that the protocol provides too much discretion to the officers and doesn't achieve its goals, which is the other major course. Then the court jumps in and says, we're not having this referendum. We're not doing this. Counsel says, I'm disappointed. A few pages later, in the middle of arguments challenging actually how the search is conducted, he just drops a couple of sentences on the facial challenge. He says that the protocol does not sufficiently control the officer's conduct and gives too much discretion to the officers to do whatever they want, which is pretty close to what we're arguing
But he
here.
doesn't explain what, that do whatever they want, as in, his point, I think, is well taken, as in, you didn't secure it, or do a contemporaneous list, or you spent too much time waiting before you vouch it. I mean,
This-
it doesn't drill down that way.
This gets into why we cited the Finch case, right? Because the Finch case is pretty clear, and I also want to mention this Kirshner case that's cited. It's not the holding of the case that it was not preserved because of the issue with being interrupted. The holding of that case is that it involved a legal issue that it was actually the defense's burden to make a record on, not the prosecution's, and they made no record on it. That's why the claim is kicked out, not because it's not preserved. The rule is still, when the court says, I'm not entertaining this, you don't have to go any further. And I want to mention page 167, the court's decision. The court decides that the protocol offered into evidence they were guided by a set of policy and procedural guidelines which limited their discretion and fulfilled the purposes of a lawful inventory search. Under 470.05, this court can decide it when the judge says exactly the thing that we're challenging. We're arguing it doesn't fulfill the purposes of the inventory search and it doesn't cabin officer discretion. At that point, the issue is before the court. Now, the second thing I want to mention is this idea of
But if
officer...
there's some issue about whether or not it's been secured, that's not brought to the court's attention, so the court didn't say, I find it was secured, I find it wasn't secured, but it doesn't matter, right? You don't have any of that.
So it's true that counsel doesn't make the argument that doesn't get a chance really to make the argument about security because the court lets him say 2 sentences about it. And then at that point, he throws a couple of sentences in, but he's already been told it's not going to be decided, I'm not addressing it. And then I think, this gets into the other point about counsel saying, like, there's no sufficient record, there's nothing asked about stuff here.
First, before we get to that, I guess on that point, your argument is a facial argument, and maybe I just have this wrong, but isn't your argument because it isn't in the policy?
Yes.
It doesn't matter what they did here?
Our
Because
argument...
let's say they secured it here. In order to make a facial challenge, it has to be bad in any application. So the policy itself has to be bad, and I thought your argument was because the policy doesn't require it, what does it matter what they did here?
Yeah, that's actually was going to be where I was going with this, is that...
I cut you off.
Yeah, is that we're raising a facial challenge because Gallick holds that unless the protocol as written is constitutional, you cannot have a lawful inventory search because as this court has held in the Supreme Court, the protocol is the warrant substitute. It would be like having an unlawful warrant and then saying, well, they still did a lawful search, so it's fine. You can't actually have that in the inventory search process. And this is an explicit holding of Gallic explaining the law that applies to that case. In the Gallic case, there was never actually any argument that the search performed in that case was unlawful, pretextual, anything. The point was that the protocol was unlawful. That was all.
They barely had a protocol in Gallic, so that was the issue. I mean, here the patrol guide was in evidence. It talks about removing all valuables from the vehicle and invoicing on a separate property clerk invoice. It talks about property of little value that is left inside the vehicle should within reason be listed in the uniform member's activity log and cross-reference. Like, what about this policy specifically makes it unconstitutional?
The specific thing that makes it unconstitutional is that there is this unregulated period of time where officers can do whatever they want with the property. And because the policy also has no temporal controls, who knows what might happen to it? I mean, I think we cited, I know this court isn't bound by it, but we cited a Supreme Court of Alabama case that explained this pretty well, that in these circumstances where there's this big time gap and there's no security, this is when property gets stolen or lost or tampered with, which is the very thing it's supposed to prevent. And I just want to say one last thing. Officer Burgos saying, all he actually said was, I have to secure evidence. For one thing, just saying I have to safeguard something is not a standard. The Supreme Court has said many times it requires a standardized procedure. One officer's idea of what safeguarding evidence could be is very different from another. The second thing is he's not talking about the property seized during the inventory search. He's talking about evidence and creating a chain of custody for a criminal case, which is not what an inventory search is about.
So if the policy said you have to secure the contents, is that enough? Without explaining how one secures?
I do think that it would have to say something about how it's secured to ensure that it actually is, because the point of a policy is it has to actually achieve its goals.
Counselor, he said, and I'm reading from page 22, question, what did you do with the items recovered from the vehicle? Answer, we placed them in a plastic bag and brought them into the precinct to create an itemized list.
Yes, so the problem is that that's not the full record. He's actually asked by defense counsel at a later point. Now, we're doing it, defense counsel actually has a lot of questions about what happened to this property. He actually asked him, so you just threw it all in a garbage bag, right? And he says, or a garbage can. He says, yes. He said, and that's what you think an inventory is. And he said, yes. He said, and then at some point you vouch for, he said, at some point. The point is that, yeah, he put it in a garbage can and brought it into the precinct, and then 11 hours passed. The waiting with the gun is 4 hours. There's still 7 hours of unaccounted time there where who knows what's happening. Is it sitting just...
Do you agree the only reasonable inference is that he waited outside for 4 hours with the bag?
No, I don't think that's the only reasonable inference. He had a partner. I doubt he just stood next to the car for 4 uninterrupted hours, but regardless, the other 7 hours, which is longer than this court was comfortable with in Gallic, for one thing, that property's just in there in a garbage can. Who knows if it's secured, if it's tied up, who's tampering with it? There is no way to know. Inventory search policies have to account for that time, or they're not doing what an inventory search is there to do, which is to secure property from being lost or stolen.
Thank you, counsel.
Thank you all.